candidate were arrested. Let's look at Twitter. Check out these pictures. Dirtiest team in America. Seattle Seahawks. One of America's the dirtiest football teams. Don't play against them and don't play with them. Okay. Just keep your distance. Don't play in that division.
First thing I'm gonna pull up is I switched up. That's good.
Oh shit. Alright, so I gotta get ready for this something. What the hell is this shit? So apparently I got a Madison Municipal Court call coming up. I gotta take this court call. He-ho. Let's give these people a call. What the fuck? Shit.
How's it going?
How the fuck do you turn this phone? Oh shit.
Hello?
Hello?
Hi, is this Mr. Lattimore?
Yes, this is John Lattimore.
Hello, this is Ryan Riley, Assistant City Attorney. Just pulling up your file here.
All right.
You are calling in to reopen a disorderly conduct citation, is that correct?
Yes, I am.
Okay. And did you plead before and now you're looking to reopen, or did you miss a court date, or what's the story?
No, I did not. Oh, yes, I did miss a court date, and yes, I did plead. I think I pled no contest. I'm not positive. I pled no contest. I think that's what I did.
Okay. And let's see how old is this citation. Looks like the citation was from August 25th, is that correct?
Yes, I think so. Yes.
Or- Alright. Did you already pay the citation?
Yes, I did the community service. I did 25 hours of community service, I believe.
Okay. I don't really have a way to reimburse you for community service, unfortunately, but yeah, I could agree to reopen it, and I could reduce the fine down to $250.
Okay. What? So you would think about reducing the fine to $250?
Yep, the citation was written for $439,
Yeah.
which is the highest bail amount for the disorderly conduct. So I would agree to reduce the disorderly conduct forfeiture to $250.
Okay. Hey, so so the reason that I asked to reopen the case was because I learned recently, or when I asked to reopen it, the day I submitted that to the courts, was because I learned that calling somebody a name is not illegal. So the police officer told me that on the day I was charged, he handed me the citation that I was charged with disorderly conduct for name calling and for calling someone a black faggot. And he said because of that, and because I was told you were harassing that person, that you are responsible for a disorderly conduct ticket. You are going to be held accountable for your actions. So that didn't happen. I never called him that name, and that was a lie. And if I did, I learned that if I did, a few months after the fact, it's called, what do you call it? So I learned that it was called,
And if you want to contact either one of our bankers,
so, I'm so sorry. I wrote it down. I wrote down the Supreme Court's decision on the matter, and they said that you are freedom of speech. Crap, I'm so sorry. I had it written down. Where is it? And I wrote a complaint for the officer. Okay, so here it is. So according to the law, name calling is legal. Offensive, harassing speech is still protected speech. A person's right to call you a FAG is protected by the First Amendment and outweighs anyone's right to be free from being called a FAG unless and until that action is so persistent or pervasive that it causes you and would cause a reasonable person to experience deprivation. So I think the officer came to my house and told me that I was doing this in a way that invaded the person's, I wasn't, but he said I was, in a way that invaded the person's life, which would constitute a loss of First Amendment protected free speech. I never seen this kid enough to call him names as often as would be needed to lose my freedom of speech rights. In fact, I never called him this name at all. I always said the same thing: go fuck yourself. And this person kept saying, be gay, as he walked past me, or he mouthed the words gay as he walked past me. And every time he did that, I'd make the same response. And it wasn't all the time. I only saw this kid randomly. But every time I did, he would make the same statement. But anyways, I looked up the law, and apparently you have to meet these standards. You have to be so persistent or so pervasive that it causes you or would cause a reasonable person to experience a deprivation. So in light of that law, I believe Officer Ryan Petchick was not supposed to issue a citation for name calling. So when he gave me the citation, I believed under some conditions that I couldn't win because I couldn't prove that I didn't say what I was accused of saying, and I couldn't, it was illegal. I believed the officer. But then I discovered that even if I said what he said, it's still protected free speech. So the officer was not supposed to charge me.
Well, I appreciate that you think you know what you found out, but the DC ordinance in the city of Madison is a very, very broad ordinance, and it includes behavior that is in a public or private place, engages in violent, abusive, indecent, profane, boisterous, loud, or otherwise disorderly conduct under such circumstances tends to cause or provoke a disturbance. And I'm reading a part of his report wherein he says he can see the video of the second incident with this person, where you have camera footage and you're yelling and directly looking out your window. Throughout the video, the officer can hear you yelling vulgarities, which include "go fuck yourself," "bitch ass maggot," the N-word, etc. So that, sir, right there in a nutshell on video is disorderly conduct. The other person to whom you were yelling in a public place was disturbed.
Okay.
So,
I
can go ahead and reduce your citation down to $250. Otherwise, we're gonna let it lie.
Okay. I heard what you just said, but I also know that there are people who speak in similar manners, and it's loud, it's disrespectful, they're swearing, and they're in very public places. They still can't be charged with disorderly conduct because they have a freedom to speak in such manners. That is a freedom. You have to use threats or violence or harass that person wherever they go in order to lose your protected free speech. That's how the law works.
Your conduct was profane and indecent
Yes.
and unreasonably loud.
Yes.
Caused a disturbance or could have caused a disturbance. It disturbed that individual to whom you were yelling such vile things at.
Yes, but
That
you have
is
a freedom to say those things.
We're dealing with a city ordinance violation.
Yeah, but the Constitution
We're disqualified.
beats the city ordinance. It's higher. Your freedom to.
You can go ahead and try that tact. It's not going to work.
I would like to try that. I would like to exercise my First Amendment rights to speak freely.
Okay, we're going to set this for a contested reopening then, because I'm not going to agree to reopen it on a bogus argument.
No, I don't
So
think it's
will let the
bogus.
judge
I
know
think
that
that's
we
a
need
poor
to-
judgment.
I know you think you know what you're talking about.
I just read it.
You know.
I just read that you have a right to yell at somebody. That's a freedom. You can't threaten somebody. You can't make them fear for their lives. That's a different circumstance. But you do have a right to yell. You do have a right to swear. That's a part of people's vocabulary. It can't constitute disorderly conduct until you start to threaten that person or make them feel like they're going to be threatened. That's a difference.
This other person's going to come in and say that your behavior was threatening to them.
Well, then the judge is going to decide whether or not yelling, swearing is enough to constitute a fear or an impression that you're going to be harmed very, very soon or because of what someone said. So that's usually what occurs. Most people know that yelling doesn't always lead to violence, and you have a right to express anger. And That's usually where people stay when they're yelling at people. If they're angry, they don't always jump to violence or imply violence. I mean, you can pick your words carefully to make sure no one feels like you're going to harm them. And that's what I did. I yelled.
That's a good one. Funny. All right. I am not agreeing to reopen this citation. It's been more than 6 months since you pled no contest. You already paid it. Therefore, the city has no reason to reopen it. I will make a note on the paperwork that we're refusing to reopen it and that you would like to have a contested reopening in front of the judge, wherein we can both argue our sides as to why it should be reopened or not.
Okay.
If the judge overrules and decides to reopen, then it will go to a trial after that.
All right, sounds good. I hope that means. I'm sorry. Go ahead.
Do you still reside at 1321 Tenkin Avenue, number 8?
Yes, I do.
Okay, that's where the paperwork from the court will come, which will tell you when you have your reopening hearing.
All right, sounds good. I hope you show up with some maturity and you don't take personal jabs in the courtroom. But
I have no time for people who would you use.
That's not up to you. You don't. You're a city attorney, so you shouldn't have personal remarks. Holy crap! Holy crap! That's a gay attorney. Did you guys listen to this person? What a gay attorney! And then someone's using an implant to make my heart beat faster. I'm pretty confident. I think that city attorney is refusing to open a case that he got away with. So if you get away with it, if you make someone believe they're guilty, even though they're in full rights, they have their complete rights, and you get them to accept a guilty plea, you can get away with this. And so the attorney is now fighting within the realm, within the freedoms he has to personally insult me, throw insults to my opinion, and he believes he has the freedom to dissuade me or to not encourage me to think that I have grounds to reopen the case or have grounds that I had protected free speech. And he just lied to me. City ordinances don't beat the Constitution. And as long as you don't use words that are known to threaten somebody or make somebody afraid, you can swear, cuss, yell at that person as much as you want, as much as you feel. So the city attorney is telling me that because I was yelling or because I was swearing, that I automatically violated a city ordinance. That's not how it works. The city ordinance is not there to interfere with your First Amendment. It's not what it's there for. It's there for people to be charged if they don't follow the First Amendment. So if someone breaks the First Amendment, like you start threatening people and you're swearing, not only can you be charged, can they describe your disorderly conduct as profane, they can also describe it as intimidation, threatening, and so forth. So the city attorney thinks he's smart, thinks he can just convince me that I did something illegal when I have every freedom given to me by this country to yell, to swear, and to call people names. I have that freedom. So to protect the city from a lawsuit, the city attorney decided to lie to me. And he has the freedom to do that. In his occupation, he has the freedom to lie to defendants. He also has the freedom to not encourage or to lie about the law and to insult you, the freedom to insult people and insult someone's opinion. So you can say your opinion is stupid, or your opinion is a joke, or your defense is a joke. But that's not a joke. It's the First Amendment. It's pretty serious, and it's there for a good reason, so that people have a way to express themselves, express their anger, in public. And that's what the First Amendment is there for. Under every circumstance, you can yell in public, you can swear in public. You just can't threaten someone in public. You cannot make someone afraid for their lives. So I think my word choices were perfect. I didn't use any phrases that people normally use to make threats. And I spoke freely. I spoke completely freely, and I yelled. That's not illegal. So I got to argue that. I'm going to argue that to a judge, that no matter how it sounds, no matter how this prosecutor is trying to dress this up, it is still protected free speech. You have to break the rules. Threats or the potential for violence has to ensue. So I think I'm going to win if the judge decides to reopen this case. I think I have a good chance of winning. And insulting my intelligence is not going to change my decision or change the law. So I might not be smart, but somebody else is. There are courts or judges or lawyers who have great intelligence. And I guess the city prosecutor thought insulting me would, if I'm insulted by his, insulted enough, I will feel defenseless. Or if he doesn't encourage or he doesn't immediately say, yeah, you're right, then I will feel wrong. Well, feel defeated and not continue to request that or say what happened was wrong. I think that's the case. So we'll see what happens. I think that's how it works. I think in reality the police officer did something wrong, and he charged me with a crime that I accepted was a crime because I believed I didn't have name calling was illegal, or I wouldn't be able to prove I didn't say what was said. But in reality, it wouldn't matter. Name calling is not illegal unless it's pervasive. It's extremely pervasive. And I don't know that person well enough, the alleged victim well enough, or I'm not around the alleged victim enough to be persistent and pervasive in his life with name calling. And this other incident is not what do you call that crap? This other incident is not what do you call that? He said there's a second. The prosecutor said there was a second incident. No, the first interaction I had with this person on this day, he walked past my car. He was walking down the sidewalk and he said the words, "Be gay," and then he looked into the ground. As I drove past him, I said, "Go fuck yourself," just like I just said to you, quietly and as casually as he said, "Be gay." I kept driving. When I got to university, by this hospital, UW Hospital, University Avenue, the person was right behind me. The person that was walking down the street was in their car, and they drove up to my bumper very aggressively and then switched lanes quickly and pulled up next to me. So he tried to intimidate me right before he began talking to me. And then I realized it was the person that was walking down the sidewalk, and he had followed me to that intersection to ask me, what did I say to him as I passed him blocks before? And I told him, "Go fuck yourself." I think that's what I said. And then he said, "Why did you say that?" And I said, "Because you said be gay." And he's like, "No, I didn't say that. I didn't say that, man." And I said, Did you follow me all the way down here to ask me that question? Did you jump in your car, race down here, run up to my bumper, switch lanes to ask me, what did I say to you? That's an act of intimidation. That's exactly how you intimidate people. And then you ask them a stupid question about why did they say something to you? It's like you're trying to harass them, you're trying to annoy them, you're trying to irritate them. You intimidate them, you harass them, or you try to intimidate them and then harass them, and then you ask them a stupid question. So you really put all the ingredients for aggravation in a very quick sequence. And that's what you tried to do on that day. You tried to quickly intimidate me, harass me, and then aggravate me. and you got the right response, except you didn't get any threats. You didn't get any threats. So this prosecutor called it disorderly conduct and just ignored my First Amendment rights. Ignored my First Amendment rights because he thought, and the cop thought, I would be too dumb to know that I had the freedom to yell, I had the freedom to swear, I had the freedom to call this man any name I could think of in that moment. And it's not disturbing the peace because you have a freedom of speech. So disturbing the peace would be, I don't know what that is, but I do know you have the freedom to yell, swear, and call people names. That's your freedom. And then what else happened? What else happened? So you have the freedom to do those things. And the prosecutor said profanity, using profanity in public is a disorderly conduct. It is not. Offensive language is selective. You can select what offensive words. The state can't decide what words are profane. But they can use that as a description for a disorderly conduct. So, I don't know, these prosecutors and these police officers are using profanity as a description for disorderly, to charge someone for disorderly conduct. But that's not how it works. Profanity is supposed to be could be used as to describe the behavior that warranted a disorderly conduct. The first thing you have to do is break your First Amendment right. And when you do, with threats or the threats of violence, someone could say that the words you chose or the things you did were profane and interrupted someone else's freedom. But that's not enough. You got to do more. So that's secondary. It's a secondary thing. So once you have your First Amendment, that's here. And in that area, you can yell, you can swear, you can be disrespectful, you can hurt people's feelings, you can call people's names. But what you can't do is make a threat, or you can't harass people. You can't do the things up here so much that the person is in fear, well, not fear, but feels like they can't avoid all the things you say to them, like your threats, your harassment, your name calling, or your yelling, or your insults. You hurt their feelings so much they can't go anywhere without hearing or seeing you interfere with their lives. So now you're into a disorderly conduct realm. You lost your First Amendment rights, and now you're into a disorderly conduct realm where the police officer can describe your behavior using profanity, vulgarity, insults, or threats, the things that you did to lose your First Amendment right. So your First Amendment right is here, and whatever you did to lose that First Amendment right is here. So the prosecutor is telling me that swearing, yelling, and calling people names made me lose my First Amendment right. Well, all of those things are in the area where I get to keep my First Amendment right. So the only thing I could have done to lose this right is if I made a threat, or if I was constantly harassing this person so much they couldn't escape the yelling, the swearing, or the name calling. That's when that's a disorderly conduct. And the prosecutors are telling me that I lost my First Amendment right, and I didn't. I was never in this area. So I was never pervasive. I was never intrusive. I didn't harass this person. I didn't follow this person everywhere they went to make sure they heard me yelling, swearing, or calling them names. And I didn't make any threats. So technically, I am still right here in the area where you're supposed to still have your First Amendment right. This area right here, where you have your freedom of speech. Positive. So you're supposed to still be here in the area where you still have your freedom of speech. Right here. Your First Amendment rights. Where you can yell, you can swear, you can call people names as much as you want. What you cannot do is threaten that person or harass that person so much. And if you do, the police officer can describe your behavior as profane, harassing, intimidating, or whatever you did to break your First Amendment right. So once you break the rules, you go down here where you can be charged for disorderly conduct. I never broke the rules. Never broke the rules. Never threatened this person. And never harassed this person so much that they couldn't escape the words I chose to speak to them. So I should still be protected. And the prosecutor is lying to me because he thinks I'm not that smart and telling me that I did break the rules of your First Amendment rights. And I did. So I'm going to go to court to prove that I stayed in this First Amendment right area and I never went down to the area where you have you're threatening people or you're harassing people so much they can't escape. You're yelling, your name calling, or your insults, which police officers would then describe as profane, harassing, intimidating, whatever descriptors that are in the disorderly conduct ticket writing they could use and tell you that you broke the law because you did these things, which aren't protected by your First Amendment right to free speech. You threaten somebody. You harass somebody so much that they can't escape your name calling. So yelling, swearing, name calling alone is not a disorderly conduct. Doesn't matter how much you yell, doesn't matter how much you insult somebody, doesn't matter what names you call somebody. It's protected. You get it? You gotta do something to lose this protection, like threaten somebody or harass them. You get it? That's when you lose your protection. But for some reason, the city attorney and the police officer don't understand the difference. They're gay people. So gay people are trying to protect each other, and the way they do it is they insult the victims and they make them feel stupid. Well, make them feel like they don't know the law, and if they don't know the law, they won't fight to protect themselves, or they won't argue for their protections. So they're trying some 1870s or 1940s tactic where you insult the intelligence of. I don't think it's not a race issue. It's a sexual orientation issue. And I think it always has been. I think gay people have been hiding behind the race issue and targeting people who are black and also not gay for with tools of psychological harassment, intelligence tests, and intimidation tests, or harassment tests, tests of insults. So I guess we're going to find out what the judge decides. If the judge decides that, hey, you deserve your First Amendment rights, you didn't violate your First Amendment, and yelling, calling people names, and using vulgarity in public is a freedom of speech. And as long as you didn't violate that right, you were never supposed to be charged with a disorderly conduct. We'll see. We'll see what the judge says. But I'm pretty sure that that's exactly what's supposed to happen, or was supposed to happen. I was never supposed to be charged with disorderly conduct. But it doesn't matter. And some people are telling me in my ears that people don't care about the law. They care about perception. If they perceive it's illegal, they won't think about what is legal. So it could be written in the law that you are protected as long as you don't do these things. Threaten somebody or harass somebody. But what you said sounds so bad that it must be illegal. Right? And I think that's what the city prosecutor is going with. I don't think the city prosecutor is going to teach people that even when things sound bad, you have a freedom to say those things. You have the freedom to say offensive things. You have the freedom to yell in public. You have the freedom to call people names in public. It's a freedom of speech. And the only way you can lose that freedom is if you threaten somebody. So And then he tried to insult me. It was a gay dude. He was threatening me. He was not threatening me. He was insulting me, insulting my intelligence. Like basically not giving me any confidence that I was correct. But I was. And the charge was not supposed to go through. And I guess on my, without support, he thinks I will bow down or accept the illegal citation and move on. But I'm not. I'm going to keep telling. All right, so let's see. I'm gonna call the city attorney back and figure out who was the guy I just spoke to. Hold on. All right, let's find out who that person was.
Hello, city attorney's office.
Hi, my name is John Lattimore, and I'm calling to see what was the name of the city attorney I spoke to a half hour ago?
That would be Ryan Riley.
Ryan Riley?
Yes.
Riley?
Yes.
All right, cool. Thank you so much. I just wanted to know because I didn't catch his name too well when he spoke.
Okay.
All right. Thank you. All right. So we got his name, Ryan Riley. All right, let's post this guy on the internet and tell everybody that he lies to defendants about whether or not they were guilty of a crime. Which is messed up because some people are not that intelligent and they'll take and they can't afford a defense attorney. And if a prosecutor is lying to them about whether or not they committed a crime, you could take advantage of somebody. You could pretty much convict somebody of any crime if they believe they are guilty. If you convince them they're guilty. So that's kind of messed up. But in reality, as written in the law and as practiced in the country, they're completely innocent. So the First Amendment is a really wide range of freedom. It is a huge freedom. Like, you pretty much can say a lot of things. Insults, disrespect, name calling, pretty much anything in the world you can think of, except threaten somebody or harass that person. And I think there's 6 other ways that you can break your First Amendment right, but that still gives you a lot of freedom. So just because it looks bad or sounds bad doesn't make it illegal unless certain things occur. And I can't believe this prosecutor won't admit that they were wrong. And has lied to me to convince me I'm guilty. And that's a bad character prosecutor. Prosecutors should only prosecute crimes that are illegal. Not just crimes that people were charged for that shouldn't have been charged. So you shouldn't continue to prosecute cases that you know were illegal. You should drop the cases immediately. So strong prosecutors should have that responsibility. So just in case anybody else meets Ryan Riley in the future, just know that he was once willing to prosecute a disorderly conduct because it looks bad. The video looks so bad that he can convince a jury or a judge that it was illegal. But even a bad sounding looking video could still be considered legal, as long as you don't violate your First Amendment right. So you don't break the rules. I think there's like 6 rules, but the 2 major ones that I can think of that are close enough to this case are threats and harassment. So as long as I didn't threaten this dude while I was yelling at him, I should be protected. As long as I didn't harass this person so much that I invaded his life, it was pervasive in his life, I should be protected. So that didn't happen, and I should still have my First Amendment rights, no matter how bad it sounds, which is why we have a freedom of speech. And it's so broad. It's really, really broad. It protects people all over the country so that you can express yourself. as freely and as much as possible. That's what it's there for. But I guess the city prosecutor doesn't believe in the broadness of freedom of speech and how hard it is to lose your First Amendment rights, or how easy it is. Threats or harassment or whatever. I think there's like 4 other ways to lose it. But the prosecutor, or he thinks I'm stupid, or he thinks the judge will take his side. So either way, you tell the public about these people, and you tell the public that, hey, Ryan Riley, once prosecuted, has no gravity, has no strength, and he will prosecute any cases that are brought before him by police officers, even if the person didn't commit the crime, because someone's feelings were hurt, or the public thinks a crime was committed, or he thinks a crime was committed, or he has to protect the interests, the financial interests of the city from a lawsuit. So instead of admitting that they were wrong, he's going to try to continue to prosecute this case so that the city doesn't get held liable at my expense. I mean, what's cheaper, to hold the conviction or to pay for this person's compensate this person for what they didn't do. So let's find out who Ryan is. Well, let's tell the public who Ryan Riley is. He decided to be a prosecutor and prosecute cases that aren't illegal. Well, innocent people. Now that's insanity. It doesn't matter, big cases, small cases. If he does it for a disorderly conduct, he'll probably do it for a murder case or a armed robbery case. If all the pieces are close enough, he'll probably prosecute somebody for armed robbery that didn't commit armed robbery, or he'll probably prosecute somebody for murder that didn't commit murder if the case is close enough. So, or if the public has a perception it's illegal, or the defendant committed a crime, he'll prosecute it. So instead of relying on the law and protecting the strength of the city, he's deciding to take matters into his own hands and prosecute innocent people because the public thinks they're guilty. Or he can persuade people into believing someone is guilty even though they have complete rights. The rights of freedom of speech. Or they weren't even at the crime, but it looks like they were at the crime scene. That's insanity. Ryan Riley is that sort of prosecutor. Dangerous. And so is Ryan Petchek. 2 dangerous people in positions of authority who made poor decisions and won't admit that they were wrong.